Hello, and I'd like to welcome you to our Private Wealth Insights webinar, Trusts for Modern Families. My name is Richard Bramley, and I'm a trust manager based in Christchurch. I've been in the trustee industry for over 30 years, with the last 10 of those at TRUSTEE'S Executors, and I'm involved with trust administration on a daily basis, along with complex estate administration. My co-presenter and subject matter expert today is Venetia McInman, who is our Senior Legal Counsel for Private Wealth. Venetia has specialised in trusts for over 7 years for both trustee companies and also in private practice. In this webinar, we will delve into trusts in these modern and ever-changing times, with a focus on the different types of trusts and how these can be tailored to meet different circumstances. If you have a specific question at any stage, please use the Q&A section on the taskbar and type in your question. We will look to cover these off as we go along or in the Q&A at the end. We will also let you know at the end how you can get into contact with us with any other questions that may come to mind. Before we discuss trusts, I'd just like to tell you a little bit more about TRUSTEE'S Executors. We've been providing services to individuals as well as corporates for the last 141 years, and we were the first company registered in New Zealand. Currently, we oversee supervision and administration of client investment assets in excess of $195 billion. Our private wealth business is a one-stop shop for wealth management services, including estate planning and investment advice. You'll see here that we believe in supporting New Zealanders as they journey towards financial literacy and making financial knowledge more accessible. This webinar is the fourth in our series, and our previous topics were investing for women, charitable trusts, the role of a trustee, and investment asset classes. We also have a couple of great topics coming out in the future, so you'll be able to watch out for these, and they're around planning for your retirement and another one on wills and enduring powers of attorney. I now have the pleasure of handing over to Venetia, who's going to start with the basics of a trust, including an interesting fact that trusts date back to further than you would actually think.
Yes, thank you, Richard. So trusts can actually be traced back as far as the ancient Greek and Roman times, and there are particularly interesting stories during the times of the Crusades where those heading off to war, well, possession being 9/10 of the law, couldn't always protect their assets while they were away. So they'd hand their assets over to somebody else who would then look after them on the basis that they would be handing them back to the original owner once that original owner came back from war. So that was the very early stages of a trust. So what is a trust specifically? Well, it's a mechanism that is set up to protect assets for the benefit of specifically named persons, so those are the beneficiaries. And there are three key roles. So you've got the trustee, who is a person who actually looks after the assets. You've got the settlor, who is the original owner of the trust assets and who transfers those assets to the trustee. And you've got the beneficiaries, who are those who are actually able to benefit from the assets. Now, a trust can be established either by deed or by will. If it's by will, then it only ever comes into effect on the point of death. If it's by deed, then it can come into effect at some point in time, or it can come into effect immediately. In the New Zealand context, it is estimated that we've got somewhere between 300 to 500,000 trusts. So just looking at the what the structure of the trust is, we've got a lovely little picture here, which you can see the settlor is sitting off to the side, who then hands the trust property over to the trustees. The trustees may be advised by advisory trustees or special advisors. And we've also got appointers who will have the ability to appoint or remove trustees. So they act as sort of the protector of the trust. And then down the bottom, you can see we've got the beneficiaries, who are those who are actually able to benefit from the assets of the trust. Yeah.
The Trusts Act 2019 has been a driver in recent times where people may have questioned why have a trust. Venetia, can you elaborate on this for us, please?
Yeah, definitely. So the Trusts Act was sort of a point which started people really thinking about whether it was actually worthwhile continuing on with a trust or not. It highlighted the fact that there were actually a lot of regulations that are required when operating and managing a trust. So things like the increased tax obligations have over the course of the years gradually got more complicated. And we've also got things such as beneficiary information, the requirement to actually notify beneficiaries that they are beneficiaries of the trust, who the trustees are, and how they can get in touch with them, and that they're actually allowed to have information of that trust. So when you're looking at whether a trust is still relevant in today's day and age, you're looking at the reasons for a trust. So basically the trust is there to help protect and preserve assets for you and your family, or whoever it is that you've set the trust up for. It can be used to help with your retirement planning, ensuring you have a robust structure in place should you end up without the ability to look after assets yourself. Or in some instances, you just don't want the hassle of having to deal with assets personally. So it gives you more flexibility as well when providing for your family. For example, if you lose capacity, if you have them in assets in your personal name, those assets can only ever be used for your personal use. Whereas if you've got them in the trust, you've got the flexibility that you've got other people who can use those assets as well. It gives you more flexibility when considering how it can be used for your family long term.
So traditionally, trusts have protected assets for relationships and against creditors. You'll see there's some other reasons here.
Yeah, definitely. So in the modern context, the protections that are afforded by transferring assets to a trust include protections, as Richard said, against relationship property issues. If you're a small business owner, then we've got protections against creditor claims and the like. But in the modern day context, families are getting more complicated. So we're seeing a lot more blended families. We're also seeing increased costs of living, which is causing difficulty for the next generation to get into housing. And so we're actually seeing a lot more in terms of multiple generations living in the same house. And these are all reasons for rethinking the way in which trusts are used and structured. So just looking at the relationship property protection side of things. Under current law, there is a presumption that on termination of a relationship, the property of that relationship will be divided equally between two parties. This can make things a little bit tricky, particularly if one party has brought more into the relationship than the other person. Good news is, if you're not yet in a relationship, you may be able to protect your assets from a future relationship breakdown by transferring those assets early into a trust. So by early, this means before you actually get into that relationship. So the example that we've got here is, so Mary is single. After years of hard work, she is finally able to purchase her first home, which she is very excited about. But she's also been seeing the issues that can arise when a relationship breaks up, and she wants to avoid the same thing from happening to her. After all, she's worked far too hard to gain what she has already. So she decides to create a trust and buy her home through that trust instead of personally. She's able to protect her home now as she's not currently in a relationship, and she does not have someone she's currently seen that could end up being a relationship with. So Mary is absolutely in the perfect position for setting up a trust in that regard. But the question arises, what if you're already in a relationship? Well, it's a little bit more tricky, but a trust could still actually help to protect your assets. So this would need to work in with your wider estate planning. It would need to be established in conjunction with a contracting out agreement. So a contracting out agreement is an agreement between you and your spouse or partner that specifically states what assets will remain as your particular separate property, what assets will remain your partner's separate property, and what will be considered relationship property in the event that the relationship should end. So by combining the two documents, the trust on the one side and the contracting out agreement on the other, it ensures that you end up with a very robust position where any assets that you settle on the trust will remain protected. So another option that you may want to consider when looking at relationship property protection is actually how can you use a trust to protect your children from future relationship property claims by establishing a trust that can receive their inheritance rather than necessarily transferring those assets to your children directly. Now, the primary focus of an inheritance trust is that the next generation will actually receive their assets by way of the trust. So it sets up the protection, and the parents, instead of transferring the assets to the children directly, will transfer them into the trust. That child becomes the primary beneficiary of the trust, and the goal is there purely to protect the children. So, Richard, I understand you've been working with some clients recently with this. You've got a couple of examples for us.
Thanks, Venetia. Yeah, that's great. I've been working with a number of clients on inheritance trusts recently. The first type and the example there is where the trust is established and activated during the life of the settlors and while the child is still a minor. The trust is set up to hold a rental property to help build wealth until the child is of age. Once the child reaches a particular age, the intention is to bring the child into the management of the trust to assist their understanding and to see the benefits of the trust, and ultimately to make the trust their own, so it becomes a forever trust for the child and their family. The second example is slightly different, where the trust is established to take effect after the settlor has died, and it also works in tandem with the will for the settlor. The trust is set up and it remains dormant until it receives the inheritance on the death of the settlor. This is particularly good if you have children with potential relationship or health issues, and an inheritance trust in this circumstance is more flexible than a trust established specifically under a will. We often receive queries from clients who are small business owners or have a director liability. Here we show how trusts can provide protection in that regard.
Yeah, so entering into a business of your own can often be a very risky choice at times. And with businesses, that risk is also personal risk. And this can also be the case where you're not necessarily an owner of your business, but you're in a business which can also provide personal risk or liability. So trust can help to protect your home or other assets by actually removing the ownership of those assets from you personally and placing them into the care of the trustees. In that instance, the trustee becomes the owner. You can still receive the benefit of those assets, but because they're not owned by the trust, any personal liability that you may have through your businesses will not follow through from your trust. The one thing that you do need to be aware of, however, is that you need to set the trust up in advance before you have any creditor or liability issues on the horizon. So if you are thinking about setting up a business, or if you're already in a small business and you don't have any creditor issues at the present, then this could be a really good time for actually looking at whether a trust may be of benefit to you.
We're seeing more and more these days where multiple generations are living in one home or in dwellings on the same piece of land. This is a complex area which is common overseas, and more so especially when children never leave home these days, or they keep returning home.
Yes, it has become quite a complex issue. Never mind all the parents who may wish that their children would leave the nest. However, with the cost of housing being so high, it can be very difficult for children to get onto that property ladder and actually purchase their first home. And as you say, we are seeing increasingly more and more arrangements between parents and children where parents are actually helping their children to be able to make their first purchase. And this can be include the parents making loans to their children, or it could be both parents and the children living in the same house, or it could be parents and children living on the same property but in two separate dwellings, and then sharing the cost of ownership or sharing the cost of any other aspects that go with that sort of arrangement. So when entering into such structures, as you can imagine, arguments do have the tendency to arise. So it's really, really important to ensure that the structure and the agreement as to how it's all going to be managed between the two groups is in place up front. That way everybody knows exactly what it is that they're going in for at the start, and they know what they're going to be dealing with. So a trust can be a suitable tool to help the structure and to actually protect this kind of arrangement. So an example that we've got here is that we've got parents who own a property. They're possibly getting on in years. The kids then come and they build on the back of the property. They fund the build themselves. So you've got the parents on the one hand who actually own the property. You've got the kids who have actually put a huge amount of money into the property by way of building, but they're not actually owners on the title. The ownership remains in the names of the parents. To further complicate this situation, the parents have got 2 other children in the wings. And the parents want to ensure that the child who built on the back of the property either won't get into an argument with their siblings, or they won't be turfed out by their siblings. And so they want to prevent those arguments up front. So they elect to put the property into a trust with a neutral trustee. So to go alongside this trust, we also have a property sharing agreement. So that property sharing agreement sets out what the termination point is going to be for the agreement on a whole. It's going to set out what happens if one of the parties actually wants to get out of the arrangement. And it also sets out who's going to be responsible for what costs moving forward. And because the parents are putting the property into a trust, the trustee is now also a party to that arrangement.
Thanks, Venetia. Yeah, it's a very, very complex area. And we also see that wealth transfer and protections between the generations is important, especially when you take into consideration the rule of 92.
Yes. So the estimated rule that 92% of families' wealth is then lost by the 3rd generation when passed directly between generations. So apparently this is largely due to the fact that those who are further down the generation line don't really understand what it is that, and they don't have any buy-in to what their forebears have actually gone to extent of actually putting together. So this is where the intergenerational wealth trust sort of comes into play. So overseas, it's sometimes known as a dynasty trust. And it's a concept where it basically utilises the maximum duration of a trust, which is allowed by New Zealand law. So under New Zealand law, you can hold assets on trust for a maximum period of 125 years from the date the trust was created. So using that maximum duration, you can help to build wealth through investments across generations with the intention that the trust will last and help to benefit your children, grandchildren, and great-grandchildren. And it also helps to avoid that 92% concept that we mentioned before. So unlike the usual expectations that children will inherit immediately from their parents upon death, this actually requires a bit of a mind shift. The intergenerational wealth concept is focused on growing the trust fund over successive generations, which casts a wider net of protection for you or your family. This intergenerational wealth trust focuses on growing your assets with the intention to assist children, great-grandchildren, and grandchildren to achieve their goals and find their own way in life by providing support from the trust fund as and when necessary, rather than simply distributing the funds out to them. It becomes a collective fund, and it has a focus of benefiting the whole of your family, building a legacy of support throughout the generations. This model also takes into account the fact that people are living longer. So often by the time parents pass away, their children are actually well grown, they're well established, they don't necessarily actually require the funds. The intergenerational wealth concept ensures that the trustees are able to have the discretion to actually consider all of your descendants and building the flexibility to support those who actually require the support, or encouraging each of them to build a successful life for themselves. So trustees have a requirement to invest prudently and in accordance with the terms of the trust, taking into account both the nature of the trust and the needs and interests of the beneficiaries. So Richard, from the trust manager perspective, how would you put this into practice?
Yes, we're doing this on a daily basis and referring to TRUSTEE'S. Also, sometimes the nature of the trust will actually dictate how assets are invested. The early example, for instance, where a rental property was placed into a trust for a minor aged child with the intention of providing that child with a home later on. This is what we call an example of a house-only trust. The only possible investment initially is the property itself. Therefore, the investment is dictated by the purpose and the nature of the trust. It may be possible once the mortgage is paid down and some surplus rental income starts to build up, that those additional funds could be invested in other ways, in which case an investment determination would be made at that time, along with a risk assessment. However, not all trusts are like that. Generally, we'd be looking at a diversified portfolio to spread risk across both asset classes and types. So again, here, it's we're important at getting proper advice, and we recommend any trustees to obtain advice from a professional investment advisor, such as the team we have here at TRUSTEE'S Executors, who can help guide the trustees to make the right investment decisions and find the right investment solution for each trust. This is one of the areas of responsibility of a trustee, and here we show you some others.
Yeah, so without going into too much detail, basically trustees have got a number of duties of care when looking after your trust. So this includes the efficient management of the trust to ensure that it keeps correct accounts, and also that it provides them to the beneficiaries. Trustees have also got to act responsibility. So what we mean by that is they're not allowed to delegate the decision making out to somebody else. They've actually got to make the decision personally. And if there's more than one trustee at the same time, then those trustees have to make those decisions together. There's a duty of loyalty, and they have to act as a fiduciary, which means that they've always got to act in the best interests of the beneficiaries. And they've also got to act in accordance with the terms of the trust. They also need to ensure that any investments, as we've already covered, are done prudently. So keeping the trustee responsibilities in mind, consideration as to who may be the best suited to be a trustee is a really, really important decision. And in many cases, the persons who settle the trust are also named as the trustees. However, it is often a good idea to consider whether the appointment of an independent trustee would be appropriate. So there's a number of factors that you'd be looking at, and this can range from ensuring that the trust has the appropriate investment management and accounting services. So a more complex trust, for example, may require somebody who's got experience in those sort of areas to actually ensure that the proper management of the trust is going through. Complex family dynamics can also benefit from having an independent trustee, as it can take the decision making away from what could otherwise cause familial arguments.
Thanks, Venetia. You've shared some great information with us, and I'm sure this has got everyone thinking. However, it is important to realise this presentation is designed to be general in nature and should form part of your overall estate planning. At TRUSTEE'S Executors, we can identify and consider with you all of your estate and investment planning needs. For us, it's about obtaining the best solution for you. Right, what should we do next? Of course, everyone is different and every family is in a different situation. I would encourage you all to seek advice and assistance, and we are, of course, here to help. Right, we've got through to the question and answer section. Let me have a look, and we do have a question. It's on inheritance trusts. I'll put you on the spot, Venetia. Question is, how would you stop your kids from shutting down an inheritance trust after you've died?
Well, it's actually a very good question, and one that comes up quite a lot. So if you're trying to prevent your kids from actually shutting down an inheritance trust and making sure that it continues for as long as possible, you'd be looking at the powers that you provide to your children within the trust itself. So, for example, are you actually appointing them as a trustee? If they're appointed as a trustee, do they have the ability to actually bring forward the termination point of that trust? Or do they have the power to appoint or remove trustees? If you're concerned with them actually closing the trust down, you may wish to consider appointing somebody else to this role instead. and perhaps just giving your child an advisory role. That is something that we can look at on a case-by-case basis to make sure that what it is that you're intending will actually work.
Great, thanks, Venetia. Right, thank you all for watching us today, and thank you for your questions. We hope you're able to feel more confident in your knowledge about trusts in these modern and changing times. This webinar has been recorded, and we'll email a link to the recording along with a trust information sheet to you as a follow-up in the next couple of days. If you do have any further questions or think of anything else in the meantime, you can email them through to inquiries@trustees.co.nz. You might also like to have a look at our website for Trustees Executors, and on that you'll find more blogs and information about investing and other subjects like wills and enduring powers of attorney. On behalf of Venetia and myself, thank you again for taking the time to join us today. We wish you all the best in your endeavours to grow and protect your personal wealth. Enjoy the rest of your afternoon.